You're rolling.
Can you hear me?
Larry, did you get my email?
I did. I didn't have a chance to respond to it. We prepared an amended like that. Talked about, we talked about usual font, the six under will probation, conditions, contact. I have a plan prepared to do that. I was going to do that. I was going to be first today, so I can about it when you write me, but I don't know if we need to set that aside, or I don't see anybody here, but I do have a complaint that we could do today if you wanted to, or again, because you haven't had an opportunity to talk about the amended final quote. There you go.
Okay. Sorry, the audio got garbled partway through, so I didn't catch all of it. But you said you're cool to the simple misdemeanor battery, right? No domestic.
Right, we had talked about that when you came down last week. I prepared an amended complaint to reflect that. So yeah, that's what I was hoping to accomplish today, but also I thought we were gonna be in person and we can hammer it out when you're down here, so. Um, Whatever you wanna do.
Okay. Yeah, I mean, sure he's fine with the no contact order. And then if you're not requesting any jail time, I think we're good to get it done.
Okay.
Do they want to break down or anything?
Do you need to have a breakout room to talk to Mr. Dawson or anything? Are you ready for Judge to come in when everything's ready?
I think we're ready.
Okay.
Nope, there's Judge. Keep ready.
I mean, I'm just waiting on you guys. I was looking, I had the note that this was gonna be by Zoom. I made that note, and also you're gonna file an amended complaint. I do not have one.
I have that, Judge, I'm sorry, I'm double booked, the jar this afternoon, so I'm just up in the court, take care of business. I come back here, we can find this.
I had no idea what's going on with the audio. This has never been echoey like this.
Yeah, probably.
Mr. Reynolds, I don't know what the echo is.
I will say it was slightly better when he was close to the microphone there at the table, but it was still a little garbled.
I asked him to go downstairs, so maybe that would handle it. And we can just shut the shop courtroom off. I didn't know we were doing that anyway. I thought it was going to be all Zoom, which I prefer. All Zoom or all in person is the best. Anyway, he's got a Mr. Battery complaint filed. He's gonna, I guess you don't even have a copy of it. He's going to email it to you now. We started streaming 5 minutes ago. So I'm going to shut down the courtroom, see if that does it.
Okay, Judge.
Mr. Reynolds, a secretary or administrative assistant thinks it's from your end because we have it on mute and it's still echoing.
See, it was better when Mr. Reynolds, it's better when Mr. Reynolds is muted.
Right. It's not echoing at all right now. So what
I
would
can try
cause
to
that?
stay muted.
Yeah, as soon as you turned it on, it did the stadium echo thing. So I don't know why. That is the problem. Because we've never had this problem before.
Is Mr. Dawson in your office, Mr. Reynolds logged in, or is he from a different location?
He's a different location. I changed an audio setting. Is it any better now?
Oh, that's way better.
Yeah, it is. Okay, that was the
I'm sorry.
problem.
I don't know what it was. Sorry about it.
Well, whatever audio setting it was, could you tell us so we know how to tell people in the future to correct that?
Um, well, I had it set to same as system, and I changed it to my internal laptop device. I think it's because sometimes I run condenser microphones through my computer.
Oh,
So,
okay. I have no idea what that means. Okay, very good. Did he send you a copy of the complaint?
yeah, looks like it. Looking at it now, and looks like what we had discussed. One count of simple Class B misdemeanor battery.
All right. Okay, are we ready to proceed then?
Yes, Mr. Dawson, can you turn your video on?
All right, very well. This is 25 CR 129 State versus Daniel Dawson. Party state appearances, please.
Your Honor, may it please the court, Larry Marchinsky, County Attorney on behalf of the state of Kansas.
Good afternoon, Judge. Mr. Dawson appears via Zoom, separately from his attorney, Kelly Reynolds, also appearing via Zoom.
All right, this is here for a plea to misdemeanor battery as charged in the amended complaint. Will one of you state the plea agreement, please?
Your Honor, it's my understanding that Mr. Dawson is prepared to enter a plea of guilty or no contest to the sole amended count of simple battery, Class B person misdemeanor. In exchange, obviously, the state made the amendment as set forth. The state is going to recommend a 6-month underlying sentence immediately suspended to an appropriate term of probation. The only condition that the state is requesting as a condition of probation is that Mr. Dawson have no contact with the alleged victim in this case, that being Mr. Rome Hunt. And I think that's the sum total of our agreement. The state is not requesting any fines or any other special conditions. Thank you, sir.
Mr. Reynolds, is that a correct statement of the plea agreement?
It is, Judge.
All right. You've heard the announcement of the attorneys, Mr. Dawson. Is that what you want to do? Plead to the misdemeanor battery in the amended complaint with those recommendations?
Yes, Your Honor.
All right. You understand the maximum penalty for misdemeanor battery is up to 6 months in jail and up to $1,000 fine?
Yes, sir.
Okay. You have a right to a trial in this case, of course, and you can request a trial to a jury. If you do that, you will have a trial to a jury. In that trial, the witnesses must testify in open court and in your presence. You have the right to have your attorney cross-examine any witnesses appearing to testify against you. You may present evidence on your own behalf and subpoena witnesses if you wish, but you're not required to do that. You have the right to either testify or not testify, whatever you decide. You are presumed innocent of these charges. Before the court or jury can find you guilty, your guilt must be proven by the state of Kansas beyond a reasonable doubt. Do you understand all of these rights?
Yes, sir.
You understand that by entering a guilty plea to misdemeanor battery, you're waiving the right of trial to a jury or a judge.
Yes.
And you're waiving the requirement that you be found guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Have you had plenty of time to fully discuss this case and your plea with your attorney?
Yes, sir.
Are you satisfied with his legal services?
Yes, sir.
You understand any agreements with regard to recommendations are not binding on the court. I could sentence you anything up to the maximum penalty if I thought that was fair. Do you understand that?
Yes, Your Honor.
Other than the plea agreement, has anyone promised you anything or threatened with anything to get you to plead guilty?
No, Your Honor.
All right. To the charge made, misdemeanor battery and the amended complaint, count one, how do you plead?
Guilty.
It's alleged on about May 22nd, 2025 here in Sumner County that you knowingly caused physical contact with another person, that being Rome Hunt, in a rude, insulting, or angry manner. Specifically, it's alleged you put him in a chokehold. Did you do what the state says you did in count one? Did you get my question?
Oh, say that again. Sorry, Your Honor.
It's alleged that you put Mr. Hunt in a chokehold, being knowing cause of physical contact with that person in a rude, insulting, or angry manner. Did you do what the state says you did, as alleged in count one here in Sumner County?
Yes, Your Honor.
All right. Based on the statements, I'll find that your plea has been voluntarily and intelligently entered. There's a factual basis for it. I'll accept it. I judge you guilty of misdemeanor simple battery as alleged in the amended complaint. I'll dismiss the prior complaint pursuant to plea agreement. Do you know of any legal reason why a sentence cannot be imposed at this time, Mr. Dawson?
No, Your Honor.
Do you, Mr. Reynolds?
No, Judge.
Any further recommendations from the state?
No, Your Honor, thank you.
Mr. Reynolds, anything to present on behalf of the defendant?
Just briefly, Judge, I will say that Mr. Dawson has kept in excellent regular contact with my office, and he's wanted to get an expedited resolution to this matter. I do know they don't have a need to have contact. There's not any potential for any further issues or anything like that. Mr. Dawson is an upstanding citizen. Otherwise, he's a hard worker. He's had to miss a fair amount of work for some of these appearances, and he's happy to do it. So he wants to comply with your probation orders, but we just request that you follow the recommendations, Judge.
All right. Finally, Mr. Dawson, do you wish to make a statement on your own behalf and/or present any evidence of mitigation of punishment?
No, Your Honor.
All right. It'll be the order and judgment of this court. You be sentenced to a controlling sentence of 6 months in the county jail. I'll grant you immediate probation from that sentence for a period of 1 year. Standard terms and conditions of probation, plus a special condition you not have any contact with Rome Hunt. You may appeal the sentence if you feel it's imposed contrary to law, and you have 14 days from today with which to do that. Of course, I impose court costs. My probation officer there is Mr. Beveridge is in the courtroom, it looks like. Mr. Beveridge, tell Mr. Dawson what he needs to do to get signed up on probation.
Mr. Dawson, can you hear me okay?
Yes, sir.
Do you have a pen or a pencil?
No, I do not.
Okay, I'll tell you what, give me your phone number and I'll have my secretary call you so we can set up an appointment.
It's 620-440-1063.
1063. Okay, we'll be calling you shortly. Thank you.
All right, thank you.
All right, we're going to go on to the next case as soon as we get the jail. Bring in Mr. Haslauer in, I think is next. All right, we'll get that done. I know she's been working on it. So,
Okay.
all right, Mr. Dawson, good luck.
All right. Thank you, guys.
Thank you.
All right, State of Kansas versus Dean Haslauer, 25 CR 57. Party state appearances, please.
Your Honor, Larry Marchinsky, County Attorney on behalf of the state of Kansas.
Good afternoon, Judge. Mr. Haslauer appears via Zoom in custody, along with counsel Kelly Reynolds, also via Zoom separately.
All right. Last time we were set for jury trial, there was a failure to appear. Issued a bench warrant, and now we're here on Mr. Haslauer's motion to modify bond conditions. Mr. Reynolds, you may present that motion.
Thank you, Judge. Yes, we had normally been able to keep in regular contact with Mr. Haslauer. He's traditionally done a good job of keeping in touch with our office. I do know we requested a continuance at the last setting, but Your Honor issued a warrant. Since he has been located, we're asking for you to reinstate an OR bond. I know we do have an appearance set for, I think it's June 29th, for a pretrial conference. We're actively in discussions, Mr. Marzinski and I, on this case. We're hopeful for a resolution short of trial But I do know that Mr. Haslauer will attend all court appearances in the future, and he keeps in touch with my office. So we're asking for you to release him, Judge.
Did he turn himself in, or was he just finally found?
I
That's all I
actually
know
don't
is
know.
he was found. I mean that he was arrested. I don't know if he turned himself in or if he had to go be caught.
I do not know the specifics of it, Judge.
I
Seems to
don't
be
know.
a big deal.
Seen, the sheriff's looking for me the first time, and I could have left town, but I just drove over to get a drink and gave another girl a ride to the gas station. And then when I seen him coming up behind me, I just pulled over before they even turned on their lights. And then they pulled in behind me and turned on their lights. So, I mean, I guess I gave myself up, but the first time I didn't know he was really looking for me. The first time I seen the sheriff was at 9:30, and I was at my friend's house talking to him, and I was standing outside my vehicle talking to my friend leaning on the truck, and he was leaning on my truck. And the sheriff stopped over there at the stop sign, and he sat there for a good 5 minutes, and I'm like, uh-oh. I said, well, I wonder if he's going to come back and talk to us or something, because usually a sheriff don't stop at the stop sign for 5 minutes. And so I sat there and waited, and then he just drove off, and I'm like, well, maybe they're not looking for me. And so
Okay. Thank you, Mr. Haslauer. I think that's sufficient for now.
All right, Mr. Marcinski.
myself over, sorry. I
Judge, I don't,
wasn't trying to.
ultimately, I anticipate that this case is going to result in a presumption of probation. Mr. Reynolds and I have discussed the case at length, and the most recent plea negotiations that we have discussed, should they go that way, would have provided for probation. Judge, even if he was convicted, I do anticipate that this case would be presumptive probation, but for a potential special rule, and that is if we were to proceed as the case is currently charged. Obviously, we haven't heard yet from Mr. Haslauer why it is that he missed court that morning, or an explanation for that. But I'm not hardcore to keep him in jail. Again, this is ultimately going to result in a probation disposition if it results in anything. So for that reason, I don't typically request people stay in custody. Obviously, as the court may recollect, Mr. Reynolds did a fairly tremendous job the last Tuesday morning trying to get a hold of Mr. Haslauer, as he detailed a little bit. So I know that doesn't help, Judge. I typically would just say, he failed to appear in court, deny his motion, but take that with the grain of salt that this would, if it does proceed, I would anticipate is going to result in probation. So,
All right. Well, I appreciate that there wasn't a massive car chase, as there sometimes is, but
Yes.
Mr. Haslauer didn't make court. I'm not really understanding why he missed it. That's the whole point. He was on an OR bond. So I'm not going back to the OR bond. So I'm going to leave the bond where it is. If he does make bond, I think there ought to be GPS tracking with CSO supervision. That should help him remember he has court. And if he does have a warrant to turn himself in, so that, but the GPS tracking will be helpful and find him in the future if he does make bonds. All right. As you all have noted, this is set for June 29th pre-trial. It's also set for trial July 7th at 9 a.m. It is second on the list. The list hasn't come out yet because Mr. Haslauer was missing. We didn't want to put him on when we didn't know where he was. So Brewington's first. I don't know if that's going or not. Do you know if that's going, Mr. Marcinski?
I have not spoken to counsel in Brewington in a few weeks, Judge, so I don't have, no, I'm sorry, I don't have an announcement on that.
Haslauer's second. So, all right, this hearing's concluded.